Please be seated. Thank you for your courtesy. This is the time set for oral argument on our case captioned State of Arizona versus Don Jacob Havatone, if I'm pronouncing that correctly. Hope I am. Our cause number CR140223. Each side has been allotted 20 minutes. We appreciate both of you providing us with your supplemental briefing, which we have studied, and we're ready for your argument. We have probably lots of questions. I have a hunch the time will go fast. Mr. Goldberg, if you want to reserve some time for rebuttal, you probably know what I'm going to say next. Feel free to watch the clock, and when we get to 5 minutes or whatever you'd like to reserve, then it's up to you to excuse yourself unless you're in the middle of a question or an answer. And but altogether you get 20 minutes. So please proceed. And if each of you would state your names for our recordings, we'd appreciate that too. That's helpful to us.
May it please the court, counsel, my name is David Goldberg. I represent Mr. Havatone, the appellant in this case. I would like to start with the court's permission, of course, in reverse, which is the issues that you've raised in your order.
We kind of like you to start with what you think is most important, so go ahead.
I think that initially I just want to make sure the court considers all the arguments on waiver. And the state's supplemental brief, since we did simultaneous, does not address it. It addresses waiver at the trial court level. The Botilla case that it cites and all the line of authority in that case go to whether, if an argument's not raised or preserved in the trial court, whether that argument can be raised on appeal. This is a direct violation of the rules of this court, Rule 31.13. It's a mandatory rule. It says that the brief shall contain and what it shall contain. And I'm going to ask the court to find waiver in this case, that the state has now, by its inaction in its answering brief, in direct response to the issues I raised in the opening brief, waived argument on the Fourth Amendment issues in this case, the application of the good faith exception in this case. The only response that it provided in the answering brief was the implied consent statute covered this, and they were both following the implied consent statute, which was not the issue I raised in the opening brief. My opening brief quite clearly raised, and I'll quote it, was the warrantless extraction of appellant's blood by police without exigent circumstances a violation of his rights under the 4th and 14th Amendments. Unquote. It's a clear constitutional issue. I also briefed at length the inapplicability of the good faith exception, the inapplicability of the trial court's precedents that it relied on. So the state was clearly on notice. Now, in my supplemental brief, I've cited 4 death penalty cases, one of which, unfortunately, was mine, Mr. Bacharski's case upstairs. And the reason I say death penalty cases, because in all of these 4 cases, Bacharski, Bolton, Moody, and I believe the case cited in Moody as well, a death penalty defendant having already been sentenced to death was held to this standard. If you do not follow Rule 31.13, we're not going to consider your arguments raised later or at oral argument. So in equity, if a death penalty defendant who may be executed someday because his lawyer failed to brief the issue is subject to these mandatory rules, in fundamental fairness, the state, and now we're talking about the Attorney General, and the Arizona Attorney General is quoted in case law and pretty much an established fact, is the #1 law enforcement officer of this state, should be held to the same standard as a capital defendant being represented on appeal. I've already mentioned the Botilla. So if we're going to get to the merits of this issue are not whether the implied consent statute applies to the warrantless blood draw in this case. And the state insists on that in their answering brief. They insist on it again in their footnote in their supplemental brief. They've completely missed the fact that regardless of what the legislature does in this state, the Fourth Amendment still must be complied with.
We want you to argue the Fourth Amendment, and we want to hear from Mr. Mills on that as well. But do you agree that if we are looking at the good faith exception, if we don't find waiver, then the statute has some relevance and some bearing?
It has some relevance, but for cases like Flanagan that this court decided long before that. But for Schmerber, and I always butcher that name, but Schmerber said what it
sounded fine to
said long before the implied consent law was passed in this state, long before, it was 47 years before McNeely, and all they said in McNeely was what they already said 47 years earlier, which is you have to excuse the warrant, case law or statute or otherwise, by state law, the Fourth Amendment requires both probable cause and exigency. And I'd submit to you that the factual record in this case fails to establish an exigency. The exigency the court talked about in Schmerber, and what trial counsel kept trying to get at in the evidentiary hearing in this case, but the state objected to, was what prevented these officers from getting a warrant. And the factual scenario is, if you look at the times here, that the accident happened 10:15 in the morning. The officer was at the scene within minutes. My client was on a backboard being treated. And this is of note because if you look at McNeely, it's at page 1562 of their decision, footnote 4, they cite 2 Arizona statutes, 2 Nevada statutes, which permit an e-warrant. Every cop in this state has a cell phone, has electronic capabilities, could have gotten a warrant right there at the scene if he believed that a warrant. But that's not what they were going on. They were going on their policy, period. And that's why I think the Flanagan case becomes relevant. If you look at...
Mr. Goldberg, doesn't the Flanagan specifically say we're not dealing with the implied consent law?
Yes.
So then, you know, it's kind of, after Flanagan, the statute is pretty low-hanging fruit.
Yes.
But are police authorities required to have interpreted Flanagan to say, you know what, although Flanagan didn't address implied consent statute, it's pretty much under the bus?
Yes. That Flanagan made clear, as clear as this court could have ever been, that Schmerber still requires both prongs, both exigency and probable cause. And the exigency in this case was premised, and this is the state's supplemental argument here, on the fact that he was being transported to Nevada. An hour and 45 minutes later was when the blood. There's 2 avenues, and if we get into a choice of law discussion, we're going to be here for a lot more than 20 minutes. But let's assume Arizona law applies. At the scene, they had the opportunity to get a warrant. They did not. If we're looking at the collective knowledge of law enforcement, which we always look at in police conduct cases, the officer in Arizona has the dispatcher call Nevada. Nevada has plenty of time to get also an electronic warrant, a telephonic warrant, because the officer who testified at the hearing said that he was at the hospital waiting for Mr. Havitone to land. He had plenty of time to get it done. But his testimony is pretty clear that he was just following a policy, that every time you have an unconscious or non-consenting, you ignore the warrant, even though he admitted he could get a warrant. So really, it falls down at the end of the day on this issue to who has the burden here. The state had the burden at the hearing, has the burden now to prove every aspect of this search is legal, and the exception to the warrant fits all of the criteria of the exception, and the only exception that they can point to now, in hindsight, assuming you don't agree that they waived it, is the exigency. And they never developed it at the hearing. The only thing they developed was, we had an accident, he was being transported to Nevada. That's it. Not anything to do with how long would it take to get a warrant? How long would the dissipation of blood occur in? None of that testimony exists. We can't even speculate that what the rate of dissipation is. Although the officer, and I probably butcher his name too, Reinmuth, I think is his name, the Nevada officer said that under Nevada law, they have up to 5 hours. And under Arizona law, since we're not really clear on the choice of law here, under Arizona law, even if it was beyond 2 hours, which is what the statute says, this court's and the Arizona Supreme Court have long accepted retrograde analysis. So there was no rush to get this done. They could have gotten a warrant easily, and the state hasn't proven otherwise, which is their burden to prove. That's why I come back to the Flanagan case, because that, as well as the other case I cited, Rumsey, in my brief,
Rumsey was a interference with attorney, right?
Yes, but I think the court's observations in both of these cases is the same. This court, in that dissipation of alcohol occurs in every DUI case, whether it's a homicide case like Flanagan, or whether it's an accident with a DUI on top of it like this case, or whether it's just your run-of-the-mill DUI like Rumsey. It's always that fact, and it's always
The
been
body is
you need
burn-
more.
The body is burning it off,
And
metabolizing it, taking it out.
That's correct.
And
But
so
we
what-
have science that proves otherwise, and we have established, even under Rule 702, that an expert qualified with the factors in the court, and I'm not going to cite this to the court because I believe these are memorandum decisions, but this court has said that it's that such testimony on retrograde analysis, even if you don't have all the factors, goes to the weight of the expert's testimony, not necessarily the admissibility. So,
We do it all the time.
yeah, you have enough here to where that could have occurred easily in this case, and there is no excuse. Now, if we get to the next step, unless the court has a question,
I want to make sure you get to Mr. Newman.
I will.
Okay.
On the good faith aspect of this, I think I briefed this in both my opening brief, my reply brief, and now again in the supplemental brief, but the trial court relied on a case that does not actually stand for what it says it stands for, which is the Gallivan case. The Gallivan case, if you read it closely, all it says is Schmerber doesn't require an arrest. That's it. But Schmerber still requires what Schmerber requires. And if you look at actual language of the case, and that's the case the state cited to them below, it's the case the court put in its minute entry ruling on the good faith exception, and this is in paragraph 4, because it's an older case where we didn't use the paragraph symbols. It says, the officer faced with inevitable and rapid destruction of the evidence and Galvin's unconsciousness could reasonably have believed that he was confronted with an emergency so that he could not delay by obtaining a warrant or waiting until he regained consciousness. And that's after they decide they're joining the other split of authority that does not require an arrest under Schmerber before a warrantless blood draw can occur, right? And I believe under Arizona law, and I'm going to hearken Judge.
Isn't head note 4 really different than the issue of the arrest? I mean,
I don't think it was a
started
germane
off
issue in
by
the
saying-
case.
They started off, I agree with you, if they ended where he said, we find the instant case Galvin's unconscious condition rendered formal arrest meaningless and unnecessary. But
Right.
then they do go on and say, the officer faced with the inevitable and rapid destruction of the evidence and in his unconsciousness could reasonably have believed he was confronted with an emergency, exigent circumstances. So, exigent circumstances is my language. So he could not delay by obtaining a warrant or waiting until he regained consciousness. I mean, I think,
You have to look at the issue that was raised in the case, which was the blood, just like in this case, was the blood constitutionally drawn. And so if that's the precedent we're left with, I'd ask the court to consider what Judge Kessler wrote in Mr. Mitchell's case that I argued here, which is, I believe it's paragraph 25, maybe misspoke, but I haven't read it for a while, but it's that the case law is unclear at best. This case doesn't say, well, under the implied consent statute, Schmerber aside, go ahead and take blood without a warrant, and the Fourth Amendment is not offended. It doesn't say that. And neither does Flanagan clearly, whether we're on Arizona law or Nevada law, they both don't none of these cases clearly say, including Jones that the state cited in its supplemental brief, which they actually got a warrant in Jones.
but what do you do then, as you admit in your supplemental brief, if you've got a statute, that can be the basis for the good faith belief. So both Arizona and Nevada have statutes that I like to call the ICU, the implied consent while unconscious clause.
Right.
No one's held those as being unconstitutional as of the time of 2012, as of the date of this event. No one's held those to be unconstitutional. No court has said you can't use this to preclude, you can't use this, you've just got to get express consent. Why can't the police just rely on the face of the statute?
Because the United States Supreme Court has spoken on it, and they're the final arbiter of what the
No,
Fourth
but
Amendment means.
What case did they say?
Schmerber
So you're
Schmerber
saying that
itself.
Schmerber itself.
is binding, controlling authority.
No question, at least as of now, no question about that. But you're saying that Schmerber would directly prohibit an ICU clause.
Absolutely. And I believe that because nobody's raised it and nobody's argued it in Nevada or Arizona, it does not matter. We are all on notice that what the U.S. Supreme Court says the Constitution is what the Constitution is, period. Whether the legislators down the street disagree with it, they disagree with it all the time. That's why I stand up in front of courts like this all the time and say, strike it down.
But Schmerber didn't deal with an implied consent statute.
No, didn't. But I'm submitting it, it makes no difference in this case, none.
And you're arguing this point, if I'm following you correctly, both on the Fourth Amendment constitutional law and on the good faith exception.
Same analysis.
Well, of course,
Same analysis.
we don't need to use Schmerber for the constitutional analysis because we've got Butler and McNeely, right?
Absolutely, now.
Yeah.
Now we do. And we also have the Nevada Supreme Court going the other way. But their reading
On good faith.
on good faith.
Yeah.
We do. And obviously, this court's not bound by Nevada law. And whether we're looking at the good faith of Perea, the Arizona officer, or Reinmuth, the Nevada officer, I briefed that as well. The state didn't respond to that as well in their answering brief. But the choice of law is something that this court's going to have to grapple with, I would think, at some level. Because clearly an Arizona officer made a decision by letting Mr. Habitone get on that helicopter and go to Nevada without seeking a warrant. So I would submit Arizona law would apply and Flanagan would control, and would also control his good faith, if you
But
will.
the problem, of course, is that the draw was made in Nevada.
Exactly.
By a Nevada officer.
Exactly. So, I mean, the choice of law is something we're not dealing with today. And just to get to Judge Johnson's question about Billy Newman.
Is the important part of what Mr. Newman said in his statement that a person exited the driver's side and ended up in front of the car?
Absolutely, because that's where
The other guy
my
was.
client did not wind up.
Okay.
And I waiver aside, because the same rules apply on developing your arguments. And I've been criticized in published opinions as well for not developing arguments and being subject to the word limitations. There was no really word problem in this case. I mean, 24,000 words in an answering brief gave the state plenty of time to develop its harmless error argument. It chose to put in one line that my client admitted 3 times that he drove. You have to look at those in the entire context of the record, in the context of the record that he's intoxicated, he just had a head-on collision, he's laying on the backboard, he's going in and out of consciousness according to the testimony. Is that a reliable admission?
And there are other witnesses, right?
The other witnesses' testimony is not clear, though. None of them could say specifically on cross-examination or direct, Mr. Habitone sitting there at the table is the man that drove the car.
But didn't the driver of the other vehicle say that he knew Habitone? I mean, I thought he said he knew Habitone.
He did know him, and he also knew that the van he was driving belonged to his mother. But that's a leap to go to that he testified that I saw Mr. Habitone driving the car. He never said that.
Did the other driver say he saw Habitone exit from the driver's side?
No, he did not say
Go to the back of the
Habitone.
vehicle, go to the back of the rear of the vehicle?
No, he said he saw a man in red shorts get out of the driver's side and go to the back.
Okay.
They both had red shorts on. It was the crux of the issue, other than obviously had the court exercised properly its discretion and granted the motion to suppress them, we may not even be here because there'd be no or little evidence of impairment.
I guess the problem I'm having is there seem to be 2 different competing lines of thought here. One is, boy, we shouldn't be trying to say it's harmless or not harmless, because that's really up to a jury. If it was error, it was error, and we can't really say it was harmless.
Right, because the standard under Bible is no influence.
But the other is that the trial judge, if I remember right, also talked about weighing under 403 whether it would confuse the jury, and we usually defer to the trial judge. What do we do with that?
Well, I only have 1 minute and 45, and I want to save at least 1 minute for rebuttal, so. Unless I can make an oral motion to suspend the rules that allow for further argument.
You could probably give each side an extra minute or 2.
So
Okay.
go ahead and answer my question.
Your question is that the trial court abused its discretion in the 403 balancing clearly because his reasoning, the judge's reasoning was that Mr. Newman said car instead of van, and the jury would be confused as to what he was talking about.
Well,
That is an
that
abuse
was-
of discretion, because
That
even.
was part of it, I mean.
But that was his main concern. How could you say that when the jury had the lone driver, Mr. Stevenson, who testified at length, I was driving the car, and the other car was an SUV? We're only talking about two vehicles here. So the fact that Mr. Newman referred to the SUV as a car instead of an SUV, I think is a decision based on a fact that's not even a relevant fact. So that in itself is an abuse of discretion under the case law, because you're relying on something that's not even a factual dispute. So I'll take my 33 seconds plus 1 minute. Thank you.
We'll add 2 minutes to each side. Thank you, Mr. Goldberg. Mr. Mills?
Well, shouldn't you wait till he gets the 2 minutes added?
I guess we should.
2 minutes.
Go ahead. Yeah, we'll give the state 2 minutes as well. Please proceed.
May it please the court, my name is Colby Mills, appearing on behalf of the state of Arizona. This court has previously held that a blood draw search, can be permissible in 4 situations, and the first 2 situations admittedly do not apply here. That's where there is a warrant or where there was express consent. However, this court has said in Estrada that there are 2 remaining avenues, the first being implied consent, and the second being a completely separate avenue, exigent circumstances.
Okay, let's deal with applied consent.
Yes, sir.
Are you saying that you can, if the officer, after Butler and Carrillo, are you saying in a non-unconscious situation, a conscious situation, that they can require the person to take the test if he refuses?
Not at all, and that's not what the statute
Fourth
says.
Amendment, and Fourth Amendment bars that too, right?
The Fourth Amendment would bar if the implied consent is revoked according to the rules of the statute, that the implied consent no longer applies and they have to either get a warrant or have the exigent circumstances.
Any case that says that these ICU cases, these unconscious clause cases, are constitutional.
The State v. Huffman followed that. And also the Supreme Court in McNeely talked about the implied consent statutes in a favorable manner.
Are you saying that Huffman held an unconscious implied consent statute constitutional?
It followed the unconscious portion of the statute.
It applied the statute.
Yes.
Did it rule on the Fourth Amendment?
I don't believe it ruled expressly on the Fourth Amendment. However, under the implied consent statute, which the state did focus its answering brief on, answering the ultimate question here before us, was this blood draw permissible? And there are
Under the Fourth Amendment?
under the Fourth Amendment or permissible under the statute, which if that follows the Fourth Amendment. However, the constitutionality of the Fourth Amendment has never been, the constitutionality of the implied consent statute as under the unconscious clause, the constitutionality that has not been challenged at any point by appellant in his opening brief, reply brief, or supplemental brief.
I think that's because he takes the approach which seems to have a lot of weight to it, which is separate and aside from the implied consent statute. What's relevant here is, was the draw constitutional, without regard to whether a statute authorized it or not, because we know that the statutes must be governed by the Fourth Amendment. So for purposes of the Fourth Amendment, have you got any argument that the Fourth Amendment allowed the draw?
A consented to search is permissible.
A consented to search?
Yes.
What consent was given here?
The consent was given through the implied consent statute by driving
Okay, so-
on that. Then it is
That's,
consent is not invalid under the Fourth Amendment just because it was given in advance and in exchange for a related benefit, the benefit to drive.
but what about Butler and Flanagan, which said that you need express consent to a search under the Fourth Amendment.
Butler speaks to the voluntary nature of consent when a suspect is conscious, when asked whether or not they revoke that implied consent under the statutory framework, whether that revocation or consent, which becomes express consent at that point if they do not revoke, whether that has to be voluntary. And that is a separate set of facts than what we have here in this case, where the suspect was unconscious before the blood draw, and by statute, a statute that has never been declared unconstitutional since its inception, since before Schmerber, after Schmerber, or even McNeely, that consent is valid consent and is not revoked if the suspect is unconscious or dead or otherwise unable to revoke.
Was an attempt made to search for cases nationwide on unconscious implied consent statutes that might be similar, and for constitutional or statutory interpretation cases based on those statutes?
Yes, and under the framework similar to what we have here, I do not believe that any court has found the unconscious portion of implied consent statutes to be unconstitutional. Now, to be fair, the implied consent statutes have been walked back since their inception well ago. Nevada itself had a very strong implied consent statute at the time of this draw, one that would permit officers, even if a suspect is conscious and revoked, permitted the officers to forcibly take the blood draw.
You agree that Nevada's now held that clause unconstitutional?
100% correct, but it also said that even under that fact, it was good faith to rely on that clause. But that case, Byers, also said explicitly, we are not touching the unconscious portion of this statute. So that portion of the statute remains.
Does
seems
Nevada?
go ahead.
No, you go ahead.
I was going to say, it just seems odd to me that there's no case on this from somewhere. I may be misunderstanding how widespread implied consent, while with unconsciousness added in, is in various states' statutes, somewhat like ours. Maybe there aren't that many.
I was searching pretty hard to find them, and unfortunately, I was not finding this particular topic
if I may,
expressly addressed.
Ask one more question. Does not or do not McNeely and Butler read together pretty strongly suggest that we have to have a warrant or express consent?
McNeely does not hold that. In fact, McNeely speaks positively to the implied consent statutes and says that all 50 states has them. McNeely simply goes back and says that we are holding by our rule in Schmerber and finding that where an exigent circumstances analysis applies, separate from the implied consent statute, but where you do not have consent, you need either a warrant or exigent circumstances, and under Schmerber, that needs to be done on a case-by-case basis, which the trial court did do here as an alternative holding to its main reasoning in allowing the blood draw evidence to be presented.
The alternative holding of the good faith exception?
The main holding is that the blood draws were permitted by the implied consent statutes of either Arizona or Nevada. Okay. The trial court then went on in its written ruling, after taking the arguments under advisement, to say that even if the implied consent statute was not there, that it found that there were exigent circumstances using the McNeely and Schmerber tests of totality of the circumstances based on the officer's testimony that there was exigent circumstances. And it went even further to say that even without those exigent circumstances, that the officers acted in good faith on both the statute and their understanding of the case law.
Reading Flanagan, Flanagan, even though it didn't deal with the implied consent statute, when it deals with exigent circumstances, it's pretty clear that it says dissipation's not enough.
Correct, and we have more than dissipation in this case.
What? what? And
It-
the problem is that in Flanagan, the court goes on and says, well, maybe there would have been a problem getting a warrant. But we don't know because the officers never tried.
Well, here, sorry, I'll speak into the microphone. Here, the Arizona officer could not get a valid warrant to cover a search in Nevada.
What,
Well, okay.
what evidence was there that a warrant couldn't be obtained in Nevada?
We do not know whether a warrant could have been obtained in Nevada. However, at the time, the statutes and the case law provided that the officers did not need a warrant.
Let's talk about good faith exception.
Yes.
We issue decisions all the time agreeing with the Attorney General that a defendant on appeal should not be able, we should not countenance an argument made in a reply brief that wasn't made in an opening brief. We do that all the time. Why should we give the Attorney General a pass in this case for failing to to address an argument that was plainly made in the opening brief?
This court has previously held that in the waiver site type context, and if there was error, it was mine and mine alone in not addressing that, this court will uphold the trial court's ruling for any legally valid circumstances, and the state, in writing its answering brief, answered the applicable question of whether or not this was permissible. We may have done so under a analysis that was different than what was brought up here, but the appellant also did not address at all the implied consent statute that applies in this case. So the implied consent statute is a valid reason for upholding that, and this court has stated that the state has not waived an argument on an issue where its argument on appeal was merely an assertion of additional grounds affirming the trial court's ruling. And that is State v. Kinney.
So is your argument that because you argued that the implied consent statute covered this, that you didn't have to argue good faith?
My argument is that I answered the broader question, and that I did not address the good
So
faith.
you sort of took
in
your
there.
chances. Because if the court disagreed with you on the broader question, then you didn't address the alternative argument.
Yes, Your Honor, I must admit that.
But waivers, I assume your argument in part is that waivers are discretionary.
Of course, Your Honor.
Is there a difference when we hold a defendant to waiver if his attorney has failed to brief something because he always has a Rule 30, he may have a Rule 32 relief, whereas the state doesn't? In other words, okay, we're going to hold you to waiver, defendant. You failed to argue something, but your relief may be a Rule 32 relief or an IAC.
There is that outlet.
You can't get that for the state.
Correct.
If we do address good faith, is the Nevada statute and Nevada case law relevant to the good faith of the Arizona officer who directed that blood be drawn in Nevada?
The choice of law issue becomes a very thorny issue.
No, it's not really choice of law.
Yeah,
We're not talking about whether it was legal in Nevada or whether it was legal in Arizona. I'm saying this is a subset as
Yes.
to the good faith of the Arizona officer.
I believe the Arizona officer would be held to Arizona law and not be expected to have a knowledge of the law, necessarily a knowledge of the law of other states. However, in this particular set of circumstances, the officer Perea stated that there was no time to do a blood draw at the scene, and the medical personnel decided that the appellant needed to be transported out of state. And at that point, once the appellant leaves the state, Officer Pereira's hands are relatively tied at that point. We would not want him to hold appellant there to say, wait, I need to go get an Arizona warrant, stay here, don't get your medically necessary treatment, you need airlifted, you can't take him away because I have to go and get this warrant before he leaves and we have to do a blood draw before he leaves. That's not a very positive or friendly thing to do. But once appellant leaves the state, Officer Pereira, and even if he were to go get an Arizona warrant, that Arizona warrant does nothing. So I would argue that forcing him to do so, to leave his investigation at the scene to go get a warrant for no legally binding reason because the appellant is out of state, is simply assigning an errand that without a purpose.
I'm sure, I assume you've answered Judge Johnson's question, but I'm not sure I understand the answer. Are you saying that was an exigent circumstance? Or are you saying that the officer could, because I thought the question was about good faith, could the officer rely on Nevada law?
The officer would rely on Arizona law, on the implied consent statute, and Arizona's application of the exigent circumstances doctrine to justify, well, this appellant is leaving the state. This is all I have. Okay. I have either the implied consent venue or the exigent circumstances venue. Either one would justify this blood draw, and I was relying in good faith upon that law and doctrine.
If we decide that the good faith exception to the warrant requirement has not been waived and we decide to address it, do you think we have to look, and maybe I'm just asking the same thing Judge Johnson asked, I'm not sure. Do you think we have to look at only the Arizona officers' good faith, or do we have to look at both the Arizona officers and then the Nevada officers' good faith?
I think you look at both officers' good faith in this. The Nevada officer, Officer Rymuth, he requested the draw, and in this case, he explicitly relied on the Nevada implied consent statute. He relied upon the exigent circumstances of coming in, the dissipation of blood. That at the time the blood was drawn, that was a valid method of conducting the draw, as Byers v. State, the state of Nevada, held that reliance upon the implied consent statute, even the portion of the implied consent statute that it later found unconstitutional, that reliance upon that statute was covered by good faith.
So what do we do if the Nevada officer says, I rely on my policy, my police, my department's policy, and that's objectively reasonable, and the policy is objectively reasonable under Nevada law. Mm-hmm. And the Arizona officer says, I rely on Arizona policy, and we hold that is not good faith because we don't think that the Arizona statute, after Carrillo, allows the warrantless, without exigent circumstances, the warrantless draw. Which controls, the Nevada or the Arizona?
I think that's a difficult question, and at the same time, that's a question we are struggling with here. It's very hard to expect either of those officers to be able to, on the spot, without legal wire training, to make that on their own.
And I don't expect an officer on the beat to be a constitutional scholar.
Yes.
But it seems to me but on the other hand, they just can't rely on saying, oh, gee, that's our department policy. If the department policy is not it can't be upheld as being objectively reasonable, then you can't rely on it. So assuming that the department policy in Nevada is good faith under Nevada law, and the Arizona policy under Arizona law is not good faith, which one controls and why?
The blood was drawn in Nevada, and by the Nevada officer. I think that would be a strong argument for why that one would control. To go back to, you brought up Carrillo. Carrillo discusses two separate tracks within the implied consent statute, and Carrillo's holding only applies to the subsection BD portion, which is when a suspect does revoke that implied consent. Carrillo expressly says we're not, that it does, subsection A and C, where the unconscious portion, that is not affected and that is not part of the Carrillo holding.
So your argument would be, is your argument that even under Arizona law, there was good faith, assuming the statute's now unconstitutional?
The implied consent statute unconscious
Yes,
clause.
assuming it's now unconstitutional under Fourth Amendment theory. Your argument that as of 2012,
That clause was,
that clause was still good and you could rely on the statute itself.
yes, Your Honor. Before I run out of the extra time that had already been allotted to me, I did want to likely turn to the Billy Newman question and his statement. The trial court is afforded great discretion in making a 403 analysis, and that is exactly what the trial court did in this case. The trial court, in looking at the statement, found that the uncertain nature of the statement, not knowing which vehicle the person, making an incorrect statement as to which vehicle the person
Some ambiguity about
let out.
naming the vehicles.
Naming the vehicles.
Some ambiguity about what color red shorts.
There's
Red
discussion
and
at the
there's,
trial
slightly
court whether they
different
were
red.
both red or one was red and one maroon.
Right.
However, that
How much ambiguity is that? I mean, doesn't that all normally just go to the jury?
yeah, the statement also does not begin to pretend who the driver was, who this statement applies to, whether it applies to the driver or someone else exiting the vehicle. And what has been somewhat lost in appellant's argument is that the red van, if you look at the photographic exhibits, that red van is nearly completely destroyed on the passenger side. There's testimony that the passenger door was completely inoperable, and one of the passengers in the vehicle who was thrown from the back to the front, that the medics at the scene had to use the jaws of life to cut open the car, the passenger side of the car, to get that person out. There's no way that either.
So what you're saying is the fact that someone exited on the driver's side, that doesn't mean he's the driver.
Correct. And in this case, there were two people that exited on the driver's side, and Mr. Newman came, by the time Mr. Newman got there, that the other, he only speaks about one person, but we know two people had exited from that side.
Now, how do we know that two people exited from that
Two
side?
people were out of the car. The appellant and Crozer were both out of the car. The only two exits from that out of the car were the driver's side door and the large hole in the passenger side of the windshield, where two other witnesses said that Mr. Crozer, the front seat passenger, exited through that windshield and crawled over the engine block before going there. And moreover, the trial court also this court would also need to find, if overruling on this part, that the statement was not hearsay, a statement that a finding the trial court did not make below. The trial court in its ruling made, just saying, assuming it's not hearsay, I still find it does not apply under 403.
I thought the trial court thought it was acceptable as a present sense impression.
At one point in the argument, the trial court in discussion makes a statement similar to that, but in making the actual ruling, the trial court says, assuming it's not hearsay, and then goes on to say, I find it more substantial danger under 403 of confusing the issue or misleading the jury, and based its finding on that. It does not touch whether or not it was hearsay or not. in the actual ruling.
You're saying that if we wanted, we would have to deal with both issues?
Correct.
Yeah. Okay, your time is up, and
Thank
thank you
you,
very
Your
much. We ran over a little bit, but we do have 2.5 left for Mr. Goldberg. Thank you,
Thank
Mr.
you.
Mills.
I want to address a couple of things the state just brought up. First of all, I would take issue with its characterization of the Byers decision, because the Byers decision does not speak, or did McNeely, highly of the implied consent statutes vis-a-vis the Fourth Amendment. If you look at the Byers decision, page 946, I'm quoting, "At no point does the plurality appear to retreat from the warrant requirement for non-consensual blood draws, and the court's description of implied consent laws does not appear to endorse our particular statutory scheme." Byers he found as, and I would ask the court to read the Idaho case I cited, State versus Wolf, which is 337 Pacific 3rd, 575, where the Idaho court this last year, the Idaho Supreme Court, found that basically what McNeely was saying, as Byers and all these other courts, is that any per se exception, whether it's by statute or otherwise, violates McNeely. McNeely just codified again and reiterated Schmerber. These statutes were always unconstitutional. It's just until trial counsel, in this case, got up and said, and you can read page 5 of the transcript, this was always a Fourth Amendment issue. The state's response, and this is another waiver issue, but the state's response to the motion to suppress filed in this case never mentioned the implied consent statute once.
The implied consent statutes really developed after Schmerber, didn't they? I mean,
Yes.
in response to Schmerber, states started instituting the implied consent statute. So
But the-
Schmerber doesn't deal with implied consent statutes.
But the unconscious driver
Right.
situation is a per se exception. Every time we have an unconscious or dead driver, forget the warrant. That is a per se exception, and it is unconstitutional after McNeely. That's what Byers says. That's what Wolf says. And it was before that. And that was the argument in this case based on Butler, Flanagan, all the way back. That was the issue. And if the state thought that the implied consent statute, which is it's arguing now as an alternative basis to uphold this, dealt away with the Fourth Amendment issue, it should have argued it to the trial judge, who never even faced that argument. And yes, Batillo and those other cases say you can uphold this on any other ground, but that wasn't even their argument below. Their argument below was that there was probable cause and there was an exigent circumstance. That's it. And when they started to get into the good faith exception at all, and Mr. Hamp, who actually is present here in the courtroom, the appellant's trial counsel started to try and probe the officers. Could you get a warrant? Was there a telephonic warrant? He kept objecting. The trial judge let a little bit of that go. So the state missed its opportunity below, too, to meet its burden to prove the good faith exception in this case. So how many free passes are we giving the Arizona Attorney General here? That gets me back to what Judge Kessler brought up about Rule 32. The Rule 32, and I do hundreds of Rule 32s in this state, hundreds. The chances of having one succeed on an IAC appellate counsel, non-capital case, is about 1,000,000 to 1. And I believe this court can just take judicial notice of all the one-line review denied that come out of the PCRs, because the burden in the case law on IAC appellate is so high, because especially in a non-capital case, it's this court, Arizona Supreme Court, U.S. Supreme Court, the hallmark of a good appellate lawyer is to winnow the best issues. So if you miss one, and then I missed it, I'm going to try and put this in my reply, or like the state just did, get up here and come up with the jaws of life argument at oral argument, it's not going to fly. And this court, and any other court in this state, is not going to find, unless it was a clear winner argument, that it's IAC. So that doesn't bail the state out. And I think, to answer Judge Kessler's question bluntly, I'm sorry, Mr. Horn, you don't get a free pass on this one. Statute's unconstitutional. The blood draw was. Thank you.
Your time is up also. Thank you both very much for your arguments. We have benefited from them and appreciate them. We'll take this matter under advisement, issue a decision in due course. Thank you.
Nice job.
You too.